This is a time set for oral argument in our case number CV230308. Each side is allocated, or KP Ventures, Well Drilling and Pump Company versus Mohave County Department of Procurement. Each side's allocated 20 minutes for oral argument. Appellant actually have an appeal and a cross appeal. So for both sides, if you wish to reserve any time, you're free to do that. That will come out of your 20 minutes, and you need to keep track of that at the podium clock. Out of respect for counsel and to avoid embarrassment, I would ask those in attendance to make sure that your cell phones are off. We have read the briefs, we've conferenced the case, we're familiar with the record. We'd encourage you to keep that in mind as you present oral argument. Our proceedings are being recorded and will be posted in due course to YouTube, so please, as you begin your presentation, start with your name and the party that you represent. With that, Mr. Hunt, you may proceed.
Thank you to the panel, and may it please the court, Marshall Hunt of Davis Miles PLLC on behalf of the appellant, KP Ventures Well Drilling and Pump Company LLC, who I will probably refer to as KP. So when I say that, not Kitchen Patrol, but KP Ventures.
We will know who you're referencing.
All right. In this case, Mohave County, the appellee, wants to deny my client, KP, any remedy or due process to present its contract claims. KP's been waiting at this point 2.5 years for that chance, and if the county has its way, KP will never get the chance to actually present its claims to a neutral, have evidence heard, and have an unbiased decision. Unfortunately here, contrary to decades-old precedents from this court and the court of the Arizona Supreme Court, the trial court wrongly went along with the county's arguments, and so we're here on appeal trying to remedy that mistake. As the court indicated, there is both an appeal and a cross appeal, and so broadly there's really 3 issues that we'll be looking for the court to decide. The first, and kind of the main issue that's been briefed by the parties, is asking the court to find that the trial court incorrectly applied the county claims statute ARS 11-622 and erred when it dismissed KP's breach of contract and unjust enrichment claims for alleged failure to timely comply with that statute. Second is the trial court's error in dismissing KP's alternative administrative appeal under the Administrative Review Act. And the third is asking the court to confirm the trial court's correct decision declining to dismiss KP's claims due to claimed failure to comply with the other coextensive notice of claim statute ARS 12-821.01.
Counsel, let me ask you just to briefly address that last point. We're here on a 54C judgment, all in, all done, not a partial final judgment. It strikes me that the 821, the denial, of the motion to dismiss, at very most would be an alternative ground. Do you view it the same way? There's nothing left pending in front of the Superior Court, and I'm hard-pressed to figure out how we'd have jurisdiction under 54C if there was anything pending there.
Correct. If I understand the court's question right, I think that the only real relevance at this point to the 12-821.01 issue is if the court were otherwise inclined to rule in my client's favor on the first 2 issues I identified. The appellee may argue that failure to comply with 821.01 would be an alternative ground to affirm.
And we'll hear more later, but thank you.
Sure.
I appreciate that.
Yeah, of course. So circling back, as the court indicated, you've read the briefs, you've looked at the record, so I'm sure there will be issues we don't address that are covered in the brief, but I do want to just hit kind of the 5 or so main dates that are relevant that I'm sure both parties will be discussing a bit. Contract awarded in January 2021. Contract incorporated an alternative dispute resolution procedure that was set out in the county's procurement code. KP sent a notice of claim under that procurement code process in October of 2021. The process continued through July 8, 2022, And at the county's election, that process did not include any type of disputed hearing, typical due process, presentation of evidence, or a decision by a neutral. And then within the 6-month period following that July 8th, 2022 final decision by the county, KP submitted 2 notices of claim in an abundance of caution in July 29th, 2022, and a notice dated November 30th, 2022. And there,
And
please.
just to clarify on that last notice, because
Yeah.
the briefs kind of migrate away from the November to the December date, was it dated late November and perhaps received or file stamped in December? Does that sound right?
That was the position of the county, yes, that they received it. Both dates are within 6 months from July 8th.
Exactly. I don't know that matters. I just want to make sure we're talking about the same document, and it sounds like we are.
Correct,
Thank
yeah. And the dispute between those dates, I don't think was developed at the trial level, but yeah, inconsequential for purposes of the appeal.
Thank you.
And so, looking at this first issue, ARS 11-622, just quickly, I think that issue is ripe for the court. Yes, the inapplicability or the waiver of the county's right to claim the inapplicability of 11-622 or the county's waiver of enforcement of that statute was first raised in a motion for reconsideration. The trial court asked for briefing on that. The county had a chance to respond. There was oral argument. If we're talking about the interference with the orderly administration of justice, which is what this court typically looks at in deciding whether to consider issues raised for the first time on a motion for reconsideration, clearly considering that issue would promote the orderly administration of justice. Because we're here, the issue has been briefed before the trial court. Now it should be decided by this court. The main issue with regard to both the applicability of the statute and the waiver of the statute is that this is a process that the county designed. The county had their form contract. They said in the form contract, you must proceed under the procurement code. And the procurement code says that notwithstanding any law to the contrary, this is the exclusive procedure to decide claims related to items that have been procured by the county. That procedure does not include notices of claim, and the parties went for approximately 14 months from that October 2021 notice of claim until the December 2022 motion to dismiss by the county before this statute, ARS 11-622, I keep wanting to add an extra 2, ever came up. That's 14 months where the county went along, allowed the parties to proceed under what they stated in their contract is the exclusive procedure. And then for the first time, when a lawsuit's been filed and the parties have already invested significant resources in proceeding under the county's exclusive procedure, they want to start talking about ARS 11-622.
And that, your argument on the procurement code being the exclusive means, and there's some contractual language in there, I think, as well, but it's largely the procurement code, presumes a procurement code could displace a statute.
Yes, and I think that this is one of the issues that undergirds the Maya decision. Some of the discussion in that decision cites to, for instance, out-of-state cases that found that arbitration that was in most cases contractually required was not a quote-unquote claim under the relevant notice of claim statutes. And so it's a little more nuanced maybe than that a contract could displace a statute, rather that once you have agreed to proceed through an ADR process, that ADR process creates a system where there is no longer a claim that arises under the notice of claim statute, if that makes sense.
And I'm glad you raised Maya and the arbitration, because that is a form of ADR, but, and I want to toss this out and get your reaction, I think it's quite different than mediation. Among other things, you have the Federal Arbitration Act, the state version, the Uniform Arbitration Act, state version, the revised Uniform Arbitration Act. I know of no counterpart for mediation or other informal dispute resolution. So It seems like Maya may have some learning for us, but I don't see it as on all fours with this case, given arbitration was an option but was not invoked. There's no argument that arbitration was, and had arbitration been, that could have been, we don't know, kind of the functional equivalent of a court decision because you end up with an award. With the ADR process here, that's kind of not where you end up. You have a decision by the procurement director, but help me understand why Maya would apply with full force here.
Yeah, so a few issues there. The first, and the court alluded to this, KP had no opportunity to decide whether it got arbitration or not. The procurement code is sort of odd and unique in that sense, is that it gives complete discretion to the county to decide, am I going to give you arbitration or am I going to give you mediation only? And at the time, the parties frankly weren't sure whether arbitration would be required. I think the procurement code could have been better worded, and I think the county probably agrees, given that they've since amended it since this issue arose. But the fact that the procurement code calls for a potential arbitration, and that matter is outside the ability of KP to decide, means that KP certainly can't be faulted for an arbitration not proceeding. But more directly on Maya, I think it is on all fours, and I think if you look at the reasoning that the court listed in the case, it really brings that home. So, I won't necessarily make you listen to me read the entire paragraph, but there's a paragraph on page 155 of the decision that starts with similarly. And this is what it says, and I'll just get into it. It says, similarly, if we accept the county's argument that the claim statute is wholly unaffected by the arbitration clause and must be complied with even before proceeding to arbitration, we create highly undesirable anomalies. And so just to stop there, that's exactly what the county is claiming here. And what the trial court accepted for purposes of its decision was KP should have both gone through with the contractually required ADR process, which in this case was heading towards a mediation, but also at the same time been on a parallel track that potentially was going to breach that contractual obligation by submitting a notice of claim under the county claim statute, and if necessary, then proceeding to potential litigation to avoid losing the ability to bring that claims. But the court goes on in this paragraph, for example, if the court were to side with the county, a person having a claim against a county covered by the claim statute would be required to first submit the claim and make demand upon the public entity for payment, even though his contract may require him to take other action first. And the paragraph goes on, but the purpose of the court in making that argument and making that point is to say it's not whether it's arbitration or mediation or something else. It's that this situation where a party is required to litigate on two tracks and two, as in this case, potentially conflicting tracks, where the contract requires an exclusive procedure to go through ADR, where on the other hand, according to the county, we also should have been breaching that requirement by submitting this county claims claim, that we want to avoid an interpretation of the contract that puts parties like my client KP into that anomalous situation. And so,
help me better understand why that parallel path would constitute a breach.
So the basic answer is the contract says any disputes, claims, controversies arising under this contract must be asserted through the county procurement code. The county procurement code says this is the exclusive procedure to assert a claim. And so that procedure does not include the county claim statute. It does not include potentially needing to file a lawsuit to preserve the claim that was asserted through the county claim statute.
But if you did file a lawsuit, couldn't you seek a stay? Ask the trial court for a stay, but while you finish business under the procurement code? What would be wrong with that approach?
It's somewhat like the approach we attempted in this case. Again, this whole situation presented a trap for the unwary to KP, where we're trying to balance these two conflicting obligations. whether you could have filed a lawsuit. I think it would still potentially be a breach in the sense that it wouldn't comply with the exclusive procedure set out in the contract. It does sometimes happen that parties file lawsuits and, for instance, the opposing party seeks a stay in order to move the parties to arbitration. But again, this whole business of trying to litigate on two tracks, seek a stay, is exactly what the Maya court was trying to avoid, and why I think in the end its conclusion that a claim covered by a claim statute, and also by, because of the procedural nature of that case, it used the word arbitration clause, but I don't see any analytical difference between arbitration and mediation given the circumstances and the reasoning of the court in Maya.
And I understand that point, but the distinction that I was trying to start with is for 11.622, that's a statute. That's the legislature saying, hey, this has to happen. And the arbitration acts are statutes saying, hey, for arbitration, here's how things have to work. And at the end of the day, you get an award that you can take to court or not, depending on which side you are. The second part of that equation for this type of mediation alternative dispute resolution doesn't exist. It's not the legislature telling us what needs to happen in and after mediation, as opposed to arbitration where they are telling us that.
Yeah, I understand. Here's maybe another angle that may help close the gap there, and it's something that I thought about a little more. Maybe wasn't. It was discussed somewhat in the context of the Fleming case in the briefing, but maybe not as thoroughly as it might have been. Part of the reasoning undergirding the Fleming decision was the language in 11.622, and I'm going to make sure I get it right here, that the 6 months to assert a notice of claim begins to run after the, quote, last item of the account accrues. And the Fleming court gave that a very broad reading to say essentially that this entire, in that case, a county employee grievance procedure, that ran for about 3 years, fit into this language of the last item of the account accruing. And so one way for the court to find the statutory authority to the extent it's looking for it is to look at 11.622 itself and say, if for instance, in this case, contract claim is not complete, has not accrued until a party has completed the entire contractual and, in this case, procurement code required claims process, administrative process, then again, the 6 months under 11.622 has not begun to run. And unless the court has any questions, I'd like to reserve the last 3 minutes.
Thank you, Counsel.
Thank you.
Mr. Ackerman.
Good morning, Your Honors. My name is Justin Ackerman, and I represent Mohave County Procurement Department. The fundamental flaw, and I think the argument being presented to this court, is the assumption that we had a valid administrative claims process. And I find myself a little awkward in having to argue that to this court, and I realize the position that's being taken here, but that is the reality that we find ourselves in. We have an administrative claims process that did not have a dual-stage review. And in the event of a lack of a dual-stage review, the legal effect under Falcone Brothers, which hasn't been spoken about yet, which I find a little interesting, but the legal effect under Falcone Brothers is that that process itself was void, that the underlying contractual provision requiring it was void. And so when we have a void process, how does that toll the notice of claim? And that is the nut of the issue before this court. And so in light of that, a couple points about the waiver argument that was raised with regard to us, and then I'll get right into Falcone Brothers. With regard to the waiver argument, the central premise is, again, that there was a valid contractual administrative process. We did not have one. The Raitan case, which I believe was what he was alluding to when he was speaking about that, had a valid administrative process. We don't have that here. Not to mention the fact that Raitan was overturned by the Supreme Court. So I think that disposes very quickly of their waiver argument, of our waiver argument. And And in addition to that, sort of from a procedural history perspective, the notice of claim issue in this case truly didn't arise until their complaint was filed, and here's why. We had a contractually required procurement process that we asked them to go through. And for clarity of the record, the contractual language said, proceed with our procurement process and any applicable Arizona law. So from the outset, the county was warning and signaling that we're not limiting our review just to that. And as we go through the process, the important piece is that at not one point did KP Ventures ever raise an issue with the validity of that process. They didn't put the county on notice like Falcone Brothers did, where they filed a notice of claim at the inception of the dispute and said, hey, we think this process is fundamentally flawed. Here's our notice of claim. We're going to go through it in good faith, and if we don't like it, we'll go file a complaint in Superior Court, and we'll challenge that and try and bring a de novo breach of contract claim.
Mr. Ackerman, let me ask you on that point. It's sort of like pushing a chain backwards. You're critiquing appellant for not invoking a process that you yourself are saying is illegal.
That the county was not aware it was illegal until the very end when it was raised by the appellant.
But now your point is that they should never have gone down that path, even though your client invoked it at various stages. And by it, I mean the procurement process, claims resolution.
Well, for fairness and clarity of the record, we did not invoke the procurement process. It was their letter dated October that said we want to go through the procurement process. Now, I can't say what the county would have done.
Let me push back on that, because the county, as I read it, had sort of three options under the code. And let me just look. You can assign the claim for a hearing, you can go to arbitration, or you can proceed to mediation. And the third is what happened here, right? And those are, as I read it, mutually exclusive. You can't do those serially.
And after those three of those options are followed, and this is on the appeal side of it, as I understand the code, after there's been an initial decision by an officer of the procurement department, then they ask for an appeal, and within that appeal, you have those three options.
Actually, and your client has those three options, right?
Correct.
So it wasn't what appellants did.
Well, that's after they've initiated the proceedings.
Correct.
And if that proceeding doesn't work out, then the procurement director, as in this case, makes the final decision, and that's where the issue comes in.
But under the code, which you're saying wasn't valid.
Under Falcone Brothers, it is not a valid code because of that case. Yes, Your Honor.
What I'm struggling with, it seems like there's sort of three sources of, probably four if you count our decisions, but three sources of law here. You have the contract, you have the code, and then you have a statute. And I understand the parties aren't on the same page on that, and I want to ask you about your cross appeal in a second. But and you're saying that because the parties proceeded down the path of the code, which you now are saying was never enforceable to begin with, that appellant should have done something quite different in October of 2021, and that they were in error by following the code that your client had put in place.
If they wanted to ultimately take the position, and this is getting all the way back to my original point about this didn't ripen until the complaint, if they wanted to take the position that they are released from the code and they get to bring a direct breach of contract claim, then yes, I think in October of 21, when they wrote that letter, which is not a notice of claim, it's a letter, to the county and said, we want to go through this process, then they should have indicated in a notice of claim, but we think this process is invalid and that we want to later bring a direct breach of contract claim against the county. I think absolutely we should have done that.
All the onus is on them.
I can't say the county doesn't have some issue with not making sure its code was correct, but the onus is on them because notice of claim compliance is on them. It's not up to the county to make sure that a plaintiff complies with the notice of claim statute. And in light of the notice of claim statute being strictly construed, I think that's where you have to shift here in terms of placing the onus, because it's not on the county to make sure they properly comply with the notice of claim statute. It's on the claimant in that stage of litigation.
Judge Brown had asked about what options appellant might have had, including filing, providing a notice of claim under 11-622, and then when that went unresolved while this administrative process, ADR process was attempted, to then file suit and stay that. Do we have any indication what your client's reaction would have been with that? There's concerns about that would be perceived as a provocative act, as breaching the contract, and I understand.
I think what's eminently clear in this record is that the county has always taken a very reasonable position in this litigation. I'm sure you've read the trial court transcripts of the hearings on the motion to dismiss and the motion for reconsideration. The county realized if there was any way that we could sort of get back to enforcing this provision, this administrative claims process, let's do it. But the problem is Falcone Brothers. The county felt, and I think the judge agreed, that you can't get around Falcone Brothers' language that says this is invalid. It's not, not invalid, void. It's void and not voidable.
Let me ask you a hypothetical question. Let's say Falcone Brothers doesn't exist, and that body of law doesn't exist. The code is valid. What should have happened here for KP Ventures to timely file a claim?
Well, we're in a different universe at that point, because if the code's valid, then they have no right to bring a direct breach of contract claim. We're just getting, and all they could seek from the Superior Court is administrative review of the ADR decision. And at that point, we're not running into these issues.
So you're saying that the county would be subject to the Administrative Procedure Act for review following an ADR proceeding?
Under its procurement code, yes.
I'll read your briefs again.
And
again, we're in a hypothetical world. But
I would ask the court to review its ARS section 412501 subpart C, and that provision of the statute recognizes that all political subdivisions or other local public agencies of the state may adopt all or any part of this chapter or the rules under the code provision. And I believe Falcone has a pretty good discussion in the later part of it about how if they had the proper dual stage review, then they could have adopted under this statute the ADR provisions and then required that kind of review. But we never got there in this case, obviously, for those reasons.
And your argument with respect to count 3 is that the trial court properly dismissed that because of Falcone? There was nothing to see?
It's the same issue. If there's not a valid administrative claims process, then there's not a valid thing to be reviewed. You're released from it under Falcone Brothers, but then you're right back to be timely comply with the notice of claim statute. And I'll be honest, when I initially reviewed the trial court's decision, I kind of scratched my head a little bit, but the more I got into this case and reviewed Falcone Brothers, I think it's right on point. I think it's exactly what had to happen here, as perhaps unfair as it may seem at first blush. And the other point I'd like to make is this case really does kind of present additional issues outside of Falcone. I mean, they like to cite to Maya, Fleming, and Stultz as their main points of authority. Maya suffers the same flaw. It doesn't deal with a flawed administrative claims proceeding. I think the court's recognition that Maya is dealing with arbitration issues is a notable distinction. I think Fleming is notably distinguishable because it involved an employee seeking lost wages, and that's a accruing issue. Here, we've known since the very first, or I should say very last invoice in October of 21, what they wanted in terms of an amount. That amount never changed throughout the entirety of this litigation. It's not some sort of accruing, changing amount. The damages have remained the same since the inception of the case and long before. So, I mean, Fleming's reasoning is not at all surprising to me because why wouldn't you extend the time when the damages keep evolving and changing? That to me makes sense. And Stultz is a 12-821-01 case. It has nothing to do with 11-622. And in fact, the issue in Stultz is whether there was timely compliance with the one-year statute of limitations under 12-821. So it doesn't even deal with tolling. And to the only extent it does address tolling, it was the argument that under 12-820-01, the very compliance with the notice of claim statute is somehow an administrative process that tolls compliance with the one-year statute. So it's just a completely different issue than what we have here.
Just to clarify, there's no statute of limitations issue in this appeal?
With
statute of
regard to
limitations-
which statute and which issue? I'm sorry, Your Honor.
Well, no, like a 1 year, you're not, the counties didn't argue that there was a 1 year statute of limitations that barred the claim.
They did not.
Okay.
No.
Could you address your cross appeal? I'm struggling to see how your client was aggrieved.
So the cross appeal, you started out by mentioning it might be an alternative basis to affirm. The reason a cross appeal was filed, and this stems from, I'll be honest, my paranoia on a line of cases from this court, and I don't have them in front of me because it wasn't raised in the briefing, but there is a line of cases from this court, it's in our appellate handbook, that says if a party seeks to expand their rights on appeal, which arguably when you have a court denying your motion for summary judgment and you're asking a reversal of that, I view that as an expansion of rights on appeal. You need and must file a cross appeal or you waive that right. And so that's the reason the cross appeal was filed. And if the court wants to look at that as an alternative basis to affirm and doesn't care about that line of case law, that's fine with me.
I always care about lines of case law. I'm just trying to understand the nature of the request and why it was listed as a cross appeal, and you've
Yeah.
answered that. Thank you.
Okay. Was there another question on the cross appeal? Okay. I think the cross appeal, the issue in the cross appeal is really the issue at issue in the main appeal. It's the same issue. Do we have tolling? Does Falcone Brothers impact that?
I'm with you. Just
Okay. I just want to make sure the court's on the same page as me.
Yeah.
So can we bypass tolling for a second? I mean, I assume that there was tolling. Just assume for
Sure.
argument that was there a valid notice of claim under 11622?
I don't think so.
At any point. I mean, and why specifically the last one?
Well-
November, and why not? The November, I'm going to call it the November 22.
Yeah, and for clarity, whether it's November, December, it doesn't matter in terms of the timing here. I always take it that when they receive it, that's when it's served, but that's an issue for another day. Just for clarity, too, the only notice of claim, as they've conceded in their reply brief, for purposes of 11622, is the last one, the November or December 2022 one. And so I think that's important here because there's been arguments that the first letter in October of 21 is somehow a notice of claim. It's not. It wasn't signed by the party. That's pretty clear. And with regard to 12/8/21/01, it was not properly served on the board, so it could not qualify there either. But it doesn't comply because the some certain language of 11622 is very particular. It says the county shall present to the Board of Supervisors an itemized claim that states minutely what the claim is for, specifying each item, the date, and the amount of each item, and stating that the claim in each item of the claim is justly due. And I take a very strict construction of that statute. I think they had to say these claims are justly due. And I think that might be parsing hairs, but I think when you have strict compliance, you have to use the words of the statute. And in addition, and more importantly, I think they needed to say, here's our itemized dollar amounts, perhaps what they used in their invoices that they attached to their October letter. But they didn't do that. That notice of claim had nothing attached to it. It had no basis for us to ascertain
Is there any argument
those
they
items.
incorporated that by reference?
No, because the notice of claim is interpreted on the four corners of the complaint of the notice of claim.
But just to push back a little bit about the detail, and I get exactly that it says minute. I mean, the statute says what it says, but I thought I just heard you say a couple minutes ago that the county knows exactly what was owed. So
It's not about actual knowledge, though. It's about what's in the notice of claim. This court has said that repeatedly, that it doesn't matter what the county may have actually known or might have known or should have known. It's what they put on notice in a formalized notice of claim. And it's I'll be honest, it's one of the rare issues that this court has repeatedly made clear that there needs to be absolute strict
done
compliance.
more than that.
I'm sorry, Your
Okay,
Honor. You're
no,
absolutely right. You're absolutely right. I don't mean to dissuade the court
No,
whatsoever. But it is strict construction. I mean, it is. And that the court really means it when it says that. And so I don't think under 11622 we have that here. And under 12/8/21/01 we have similar issues. I've raised a whole host of some certain issues in the briefing. This court has had some recent cases that discuss when someone puts in a some certain, we want X amount and plus, applicable interest. There needs to be a way to interpret from the four corners of that document how we figure out what that interest is. And I think they've got a huge issue with that here. They put a percentage rate in, which is, I get some part of the way, but then how do we calculate it? From what date to what date? And I think the notice of claim under 12.82101 is completely deficient in that regard. Unless the court has any other questions, I'd ask it to affirm.
Thank you. Mr. Hunt, rebuttal. And I suppose response on the cross appeal if you have anything to add, but I.
Yes, thank you. And I'll probably hit just some quick bullet points in my last 3 minutes here. But to start, I believe counsel's quote was, "unfair as it may seem." And he's right. This decision of the trial court is unfair. And I think the province of this court, when presented with an unfair ruling, is to find a reason to do the right thing and send this back with reversal. On a few things that were discussed by counsel in his presentation, the Falcone case and the whole question of whether the procurement code properly or improperly limited KP Ventures to administrative review does not make the entire ADR process invalid for purposes of tolling under the case law that we've discussed and or under 12.821.01. That's nowhere in the case law. That's nowhere in the text of 12-821.01c. The ADR process itself, which was submit a claim, have it denied, submit an appeal, have the county refer the case to mediation or arbitration or a hearing, all that was required by the contract, complied with by the parties with no dispute or question about it. And then at the end, once that process was complete, this question of whether KP is limited to judicial review under the Administrative Review Act or not arose, but that doesn't mean that tolling didn't already occur and isn't already applicable. And that really answers the cross appeal as well, because as counsel indicated, it's kind of the same issue. The question is, what is the effect of this ADR process if at the end, the one thing the parties have argued is whether that process properly limited KP to judicial review. The last couple of things I'll quickly note on the some certain issue, as set out in the briefing, that was waived for purposes of appeal, not discussed at all in the trial level, and therefore not appropriate for this court, both on the court's jurisprudence on that issue generally, and specifically because that in this case that issue has not been sufficiently developed to allow the court to rule. We could go on. Justly due, for instance, that was discussed. That's not magic language that has to be included. And then the last thing I'll just mention, we haven't had a chance to discuss it, but I would refer the court to the briefing because KP does still have the right to assert its administrative appeal. That was, again, admitted by the county that they did not move to dismiss that in any cogent way, and so it was error for the Court of Appeals to dismiss that claim as well.
Can I ask you about that? That was addressed, though, at a hearing on the reconsideration motions, right?
It was not on reconsideration. It was on a motion for clarification.
Fair enough.
By KP.
That's correct, but it was addressed in open court.
So it came up in the in that motion and in the oral argument on the two post motion to dismiss motions. In my opinion, insufficiently developed to be raised for purposes of appeal, and as the county admitted, they did not raise it in their motion to dismiss.
Thank you.
Thank you.
Thank you. Mr. Ackerman, I think you have no further things to say on your cross appeal. Is that fair? That's fair. Very well. Counsel, we appreciate your briefing. We appreciate your argument here today. 11-622 is not a provision that this or any court really has had robust opportunity to address that you've given us. And the procedural background is quite unique in this case, so you have given us a great deal to think about. We will take the matter under advisement and we'll issue a written ruling in due course. Thank you.